Hello and welcome to our show, 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me today. Today's question is, Sergio, my fiancé and I are about to marry, and we wanted to do a prenuptial agreement to protect our assets. However, the wedding is happening soon, and we have no time to get a prenuptial agreement done. But we're still concerned about the financial consequences of divorce. What's the best way of handling this situation? Well, first, let me congratulate you on your marriage, and I commend you for recognizing the need for a prenuptial agreement. As you know, a prenup helps protect your financial assets in the event of a divorce. However, you may find yourself in a situation where you and your fiancé simply do not have the time to get this important project done before the wedding. Even if you are able to get a prenuptial agreement done quickly, you run the risk that a court may later find that this prenup was invalid simply because it was done too close to the wedding. That is, the court may find that it was involuntary, it was under duress, you were kind of forced to sign something on a fly without the parties really sitting down and figuring it out and knowing what they were signing. So you run the risk of the court finding that this prenuptial agreement is invalid. So what do? Well, you don't lose hope. Why? Because you call our firm. And because it's still possible for you to complete a postnuptial agreement after you marry that will correct all the problems of your prenuptial agreement. So let me explain. A postnuptial agreement operates in a similar way to a prenuptial agreement in that it is a contract between spouses that stipulates the separation of marital assets in the event of divorce. It could also address the issues relating to alimony. So what's the difference between these agreements? Well, a prenuptial agreement is signed before the marriage, while the postnuptial agreement is signed after the marriage. When the agreement is signed after the marriage, we avoid the issue of the other party later claiming that they felt forced to sign the agreement because they were rushing to a wedding. The postnuptial agreement also helps solve another problem, which is the accusation of the spouse that's trying to invalidate it, later claiming that they had no knowledge of your financial assets because they were rushed into the wedding. However, when there's a postnuptial agreement done after the wedding, without the stress of an upcoming wedding, the spouse is presumed to have more knowledge of the financial assets, and therefore it's much tougher for them to use that argument to invalidate the postnuptial agreement. So the question now becomes that after the wedding ceremony, after the marriage is done, is your spouse willing to sign any type of postnuptial agreement? What if they disagree? What if they refuse to sign any type of postnuptial agreement? And now you find yourself without a postnuptial agreement and no prenuptial agreement. Well, that's where you have to make the decision of whether to continue with the marriage. Keep in mind, the sooner you divorce, the more you can protect your financial assets, as most of these assets are probably acquired before the marriage if you divorce soon after the marriage. In fact, you may achieve almost the same outcome with a short-term marriage than you would with a valid prenuptial agreement. I hope this isn't too confusing in this short video, but the idea is that if your spouse refuses to cooperate with any type of postnuptial agreement, you could use the divorce as leverage to kind of persuade your spouse to agree to a postnuptial agreement. The longer you stay married, the more you'll be financially compromised. Once your spouse understands that, he or she should cooperate with the postnup. So when in doubt, do the postnup or get out. Finally, if you and your spouse agree to a postnuptial agreement, please keep in mind that it must be completed correctly. Otherwise, the agreement could be deemed to be invalid. This agreement should be written in a way that complies with Florida law. This includes the fact that the agreement should be fair to both parties. That is, it's not unconscionable or too much in favor of one party against the other. The other requirement is, ideally, there should be full financial disclosures attached to the agreement, unless it's specifically and correctly waived by both parties. I always like the idea of having both parties represented by independent counsel, although that also could be waived. I always like to include it because that avoids arguments later from one spouse claiming that they didn't understand the agreement, they didn't know what they were signing, etc. Again, if the agreement is not done properly, it will not be valid. So don't use the forms on the internet, which may or may not comply with legal requirements. Remember, the agreement has to be drafted properly and it must be signed properly. So, bottom line, don't take chances on something so important. It's worth your investment in time and money to consult with an attorney to make sure this process is done correctly so that your agreement is held to be valid later on when you really need it. I hope this short video provided you with some guidance about what you can do if you wanted a prenuptial agreement but just didn't have the time to get it done before the wedding. Thank you again for joining me today, and as always, stay informed so you can stay strong.